If you've enjoyed watching this video and would love to stay up to date when I have more content like this or something similar that you may be interested in, please like and subscribe to this channel and click the bell so you get notifications. And I hope you have a great day. Thank you everyone for joining us today on what I've called the legal lesson. Today we're going to discuss why buyers and sellers should hire a real estate attorney for regular real estate transactions. And this will be for certain circumstances that you may not already be aware of. So to help with this legal lesson, I have Shawn Head with me today. He is the founder and managing member of Head Murphy Law. Shawn has been named as one of Metro Detroit's top lawyers for several different years by D Business magazine. He's also been selected as a rising star by Michigan Super Lawyers for several years and was selected as a top attorney for Michigan Super Lawyers in 2023, 2024, and 2025, which is a recognition limited to the top 5% of attorneys in the state. Shawn is a member of the State Bar of Michigan, Illinois, Livonia, and Michigan Association of OWI attorneys, and he is a real estate attorney and business attorney. So thank you, Shawn, for being here. I greatly appreciate it.
Thank you, Patrice. I appreciate you having me.
Yeah, you're welcome. So the first question I have is in other states, there's often an attorney involved, not every state, but in some states, there's an attorney involved essentially in every transaction instead of just the title company. And then other states, they have the attorneys and the title companies involved in transactions. So I was curious as to why Michigan focuses on using title companies only, except for when we do have those special circumstances in our transactions.
That's a good question. For example, Illinois requires an attorney to be involved in every residential real estate transaction. Michigan has no such requirement for any attorney at any stage. In fact, there's no requirement for a title company to be involved in Michigan real estate transactions either. And really, I kind of looked into some of this because I was curious as well. And the short answer is that it's a state legislative preference. The Michigan State Legislature has decided that in order to keep real estate transaction costs down and to provide the freedom and flexibility of people buying and selling real estate, they pretty much put the burden on the buyer or seller to understand what they're doing with the transaction and on other professionals that are involved. So a prudent purchaser, a prudent buyer would want, at a minimum, a title company involved to make sure that they understand what they're buying. There's no liens or encumbrances or undischarged mortgages or things like that that are on the title, and that there are no holes in the chain of title or potential claims to the property that you just wouldn't see by pulling the last deed that's been recorded on the property, things like that. So at a minimum, a title company should be involved. But as to why Michigan doesn't require attorneys, I think it's really just that the Michigan legislature decided they want to keep costs down at real estate transactions, and that's one way to do it.
Yeah, that's what I always thought myself, but I never really knew. And it makes sense because I know, in Illinois and New York and those are higher income areas. So I said, okay, well they can afford to do that. So
Well, and another issue too is some states like Illinois, for example, decided that explaining the closing documents, explaining, the mortgage lending documents or uh, even purchase agreements and, different nuances of the deed, those types of things, describing those and explaining those to customers or clients is the practice of law. So Illinois for example, has taken the position that explaining those legal documents is the practice of law that can only be handled by an attorney. Michigan's been a little bit looser in that requirement, saying that, professionals who prepare those documents are able to explain those in limited situations without being determined to be practicing law.
Oh, okay. So in some cases it's just doing exactly what the title company would do, just now you have an attorney and you're paying for that.
Right, right.
Okay.
Now, in financed transactions, whenever there's a lender or a financial institution involved, they're always going to require, at a minimum, a title company to be involved, which is good for the overall transaction.
Absolutely. Um, okay. And so people who don't know, why is it important to hire an attorney that specializes in real estate for their real estate needs over an attorney that, understands real estate, but they don't specialize in it?
Sure, I think that's a good question. So pretty much any attorney can understand in general, because they've all taken real estate classes in law school, that the importance of, what a conveying document is, a deed or those types of things. But there's some nuances in the practice of law that only comes from experience in dealing with real estate transactions on a regular basis. And I could list some examples if you'd like, but really that's what it comes down to is an attorney that regularly practices in real estate law will understand some of the not only the different nuances that real estate law that happen when dealing with real estate issues, but also kind of the trends in the industry as well.
Yeah, definitely agree with that. So what is the most common reason someone hires a real estate attorney to help with their real estate transaction outside of special occasions like, well, special situations like short sales and probate?
Sure. So obviously, if there is an issue where an attorney is required, like a probate issue, where a deceased person owns the property or somebody who's subject to a conservatorship or is otherwise incapacitated. So there's, some representative that needs an attorney to kind of help close the transaction. Those are certainly reasons why you would need an attorney at a real estate transaction. Other reasons are what I've found is a lot of real estate investors that want a real estate attorney to kind of guide them through the process. Also, are handling some of their business law needs. They often want to have a real estate attorney because it's a piece of what the attorney is doing for them as a whole. I've noticed a lot in my practice that a lot of real estate investors or people from out of state that are coming into Michigan are either used to having an attorney explain the documents and the process to them. So they want that comfort. Or really anyone that has a question and want a deeper understanding as to what they're signing, why, what their options are that are maybe not typical, or not something that sometimes a real estate agent doesn't feel comfortable giving detailed legal explanations for certain parts of the transaction or certain issues that may come up during the transaction. So they may feel that they would be better suited having their clients have an attorney represent them and explain some of those things. So really anyone that wants a deeper understanding of the transaction or has any problems during the transaction should involve a real estate attorney as early in the process as possible. The earlier an attorney can get involved, the easier it is to cut off problems or prevent problems before they become bigger problems. So that would be my recommendation. Anybody that has any questions about the transaction or want to cut off potential problems can involve a real estate attorney. And sometimes it's as easy as just reviewing closing documents or reviewing the purchase agreement and the closing documents. That happens all the time. It's not very expensive. And, we often give our clients the opportunity or the option of us going to closing and explaining every document to them, or just reviewing and then going through some things that may jump out at us, or just reviewing and approving documents.
Okay. And do you often find that you need to change something, or is it more so just explaining what they're signing?
It's more so explaining. I think that any attorney could read some other document that another attorney or real estate agent or title company has prepared and have personal suggestions or requests. So it really comes down to what is the client's goal. If it's to close a transaction adequately as efficiently as possible, then maybe there's not a need for some back and forth. However, if we notice something that could be a legitimate concern or a concern post-closing or pre-closing, we may want to try to modify some documents to account for that. So I hope that answers your question.
Oh no, it definitely does. Because I do feel like sometimes, not that it's being met that many of them, but it's almost as if sometimes, an attorney is trying to find something to justify the payment, but then at the same time, I more recently have had when I've had cash transactions, right? So you'll use one title company and you're just going to be the listing agent's title company where
It's like if I could have used someone, a different title company would have been better. I mean, because they, either not completely involving me in the process or they messed up the transaction afterwards closing or before. And if I didn't say anything, it would have been easily missed. And I'm looking at 30 pages of paperwork that if they did it right, it wouldn't have been an issue in the first place. So,
Yeah, I can see, from some perspectives, it feels like sometimes attorneys make things more complicated than they need to be. And unfortunately, there are some attorneys that do that. I think that anytime you're having a transaction that does not involve a title company, you absolutely need an attorney. I think that I would find it hard to recommend that someone not use either an attorney or a title company.
yeah. Um, yeah, it's only been mostly just, well, I mean, because we had one where they switched the title companies, because the first one was fine. They switched title companies and they were in Florida. And I think they were like just getting started, so they had limited things they could do. And I really think because they collected the $3,600 that the seller needed to pay for the water bill that was outstanding, but they didn't pay it until 3 months later. And it was only when the buyer reached out to say, "Hey, see, saying it's not been paid, or we're paying it today," and then it didn't get paid till 2 months after that. So that was alarming. Um, but anyway, so when landlords and property managers need to evict tenants, how fast does hiring an attorney speed up the process or help it get completed more effectively?
Sure. So that's a good question. So one thing, it depends on who the owner of the property is. So, for example, if we're talking about a rental property and the owner is a company, an LLC, for example, which it should be in most cases for a rental property, for business and liability reasons, only an attorney can represent that LLC. So, otherwise, it's unauthorized practice of law, and most courts will determine that. So, if you're an LLC and you're trying to evict someone from the real estate from the property, you have to have an attorney. Most judges in the eviction process won't let the owner of the LLC handle the eviction themselves. So that speeds up the process because you don't find that out until you're in court for the first hearing and the judge says, you need an attorney, so we're adjourning. And that then will be determined, the next court date will be determined on the court schedule or, how long it takes to hire an attorney or find an attorney, those types of things. Also, there are some certain pitfalls that can happen during the eviction process that a real estate attorney should be able to avoid. For example, typically in almost all types of evictions, you've got to send out some type of a notice or demand for possession before, and then let that time or that notice period expire before you file a lawsuit for possession, a complaint for possession to retake the property. If that notice is defective, sometimes it's as simple as not checking a box on the court form, and you end up filing the lawsuit and then showing up to court. Either the judge or the defendant, the tenant, can say, this notice is defective because, and show that there was a mistake. And if that becomes a winning argument and the notice was improper or a box wasn't checked that needed to be, sometimes the process will have to start all over again. So that could delay the process, a month or 2 months or more, depending on the type of issue it is. So in general, an attorney who's well versed in evictions can speed up the process. How much depends on the type of notice that's given or some of the details, but almost always an attorney will make the process go quicker.
And then well, I'm assuming it's not the same process, but when someone buys a home and the homeowner needs to stay after closing, but when their time is up and they refuse to leave, how is that handled?
It actually is handled in a very similar way. So if in a common way would be, you have closing and then the sellers want to remain in the property month to month for 2 to 3 months, maybe longer, depending on the situation or whatever was negotiated. And if they're paying a monthly rate for rent to stay during that time, then you almost have to give a 30-day notice one interval of notice before you can sue for possession. So, that it is a very similar process.
If a damage deposit, which people know is used to protect the buyer, in the event the seller damages the property when they're staying there after closing. Um, and then say the damage deposit isn't enough for the damages that are there. How is it best determined how much the seller should pay the buyer in the event of a lawsuit?
Well, I think you've got to somehow measure the amount of the damages. So what would it cost to repair the damages? So let's say the seller, knocked a bunch of holes in the wall when they were removing their furniture, and so now there's a bunch of drywall that needs to be repaired, or, just for a simple example. Then in that case, the measure of damages would be, obviously outside of the damage deposit, how much would it cost to make those repairs to get it back in the condition that it should have been in when the seller's left? And that would be the measure of damages there. One important thing to consider is that in my recommendation would be that every purchase agreement have a attorney fee provision in there, so that if there is a dispute related to anything covered by the purchase agreement, so damages to the property, for example, or initial disclosure issues, what is another example, there should be a provision in the agreement between the parties that if there is a dispute, the prevailing party is entitled to recover costs and attorney's fees. That provides a lot of leverage in negotiating and resolving those types of disputes. Because let's say, for example, the damage deposits exceeded and the damage caused to the property is $1,000. A buyer is going to be hard pressed to find an attorney that's going to charge less than $1,000 to handle that dispute, to try to recover that $1,000 in damages from the seller. It's going to cost more in attorney fees than it's worth. So then the buyer's got to make that choice. Like, do I just eat this cost, or do I overpay and do I pay more for an attorney than this is really worth, which usually doesn't make sense. So having that, so in Michigan and in most states, each side is responsible for their own attorney fees, unless there's a contract that shifts that burden, or there's a statute or court rule that specifically awards attorney's fees. So in real estate transactions, most of the time, the contract is what would give the ability to shift that burden and make the losing side or the other side pay costs and attorney fees.
Yeah, no, that definitely makes a big difference for sure. Would you include missing items as part of the damage as well?
I would, especially if they're specifically noted in the purchase agreement. So like an appliance or washer and dryer, for example, just an easy example. If that's listed as something that's supposed to go with the property, then replacing that would be the measure of damages if the seller took that with them when they shouldn't have.
And so if the seller backs out of selling their home for a non-contractual reason, meaning that and it wasn't agreed upon in the purchase agreement that they could back out for this reason, is claiming interest on the property, meaning when the buyer decides to put a lien on the property, should that be considered, or is it better to just move forward with the lawsuit to account for damages or proceeding with acquiring the home?
I think that can be considered in some instances, because there is a contractual interest to purchase real estate, and if you wanted to record a lien for that claim of interest, then that is one way to negotiate or have to force the seller to deal with that issue, and they can't ignore it. One option that people have when there's a breach of a real estate purchase agreement is to force a court to enforce the agreement to sell the property. It's called specific performance. So if there's a breach of contract, a breach of the purchase contract, and the seller refuses to sell the real estate for an invalid reason, the buyer has an option to sue them for specific performance to force the sale pursuant to the contractual terms. Recording that lien or a claim of interest prevents the seller from just selling it to some third party while that dispute is going on. at least in a traditional sale, because a title company, if they're involved and there's financing, they would notice that claim of lien and they wouldn't close the transaction until that claim of lien was resolved. So the seller would be forced to deal with it. And if he did sell it to a third party, maybe an insider, a deal without involving a real estate attorney or a title company, then whoever took that property would still have that lien on there. They just might not know about it. So yeah, I think that it is a good mechanism, especially in situations where the buyer wants to proceed with the sale and wants to force it.
So essentially, they should do both.
Should do both, yeah, in a lot of situations, probably most situations.
Okay. Um, so for wholesalers, which people don't know, that's someone who signs agreeing with the seller to purchase the home, and then immediately sell that agreement to a real investor for more money. So they're in it just to make a profit from the agreement. And it's common that the wholesaler will put a lien on the home to induce the seller to move forward with the closing once they find out that the person is wholesaling the property for more money.
Right.
Would this scenario be different because there was an agreement, or is it because they're kind of deceiving the seller that it may not be?
Well, I think whole, wholesalers get a bad reputation, and sometimes that's deserved because of how they operate. It's actually not technically legal to wholesale if you do it more than 5 times in a year. So wholesalers that are doing it all the time, they're likely breaking the law because you have to have a broker's license or own your own property to be doing that. Um, that more than a certain amount of times per year.
Oh, wait,
And
before you go on, are you saying like in order to do it more than 5 times per year, they have to own a home and be a broker and or be a broker, or just to do it, period, they have to have their own home, own their own home?
if you're doing it with your own property, they own. So I guess if we're using a wholesaler as an example, they're not owning the property ever. They're signing a purchase agreement as a buyer, and then they're selling it for a profit to another buyer, and then just keeping that profit. If you do that more than 5 times, the law requires that you're a real estate broker. So wholesalers are often breaking the law by doing exactly what they're doing for a business. It's not that well enforced, but at any time, the state could start enforcing those issues and basically prosecute these people for not having a broker's license. So it's something that wholesalers should be very careful of. If they're going to be that involved in real estate, then they should get a broker's license and do it the right way. And brokers are allowed to wholesale. That's, I do have some clients of mine that often wholesale, either by design or just as part of their business. And they're brokers, so there's nothing wrong with that. Going back to your original question, is it permitted to record a lien if you're a wholesaler? Yes, technically, because you do still have a contract to buy the property. So that is a valid contract. A wholesaler should be careful to make sure that the contract allows them to do that. My recommendation would be that they put a provision in the purchase agreement that explicitly says that they're allowed to record a claim of interest until between the signing of the purchase agreement until the transaction either closes or otherwise terminates pursuant to its terms, for a valid reason. So I think that in most times, it would be a good practice for the wholesaler's point of view to record a lien. And as long as they're doing it the right way, that's something that's regular and common.
And they could really still acquire the property and sue if for some reason the seller is finds out and they have a problem.
Correct. Correct.
Okay. And that was interesting to know because I've told many times that, well, I guess it could be true, right? That if you're a realtor or broker and you go in trying to sell the house, but then you later on wholesale it, that's a problem. But if you go in pursuing to wholesale the house and then that didn't work out, so you list it, that's completely fine. But you can't do it the other way.
Yeah, I guess I I don't know if I understand your question exactly. So,
So let's say, let's say I want to wholesale a house. I'm a wholesaler and I'm a broker, right?
okay.
And okay, what am I gonna do with this house? Okay, so if I meet the person initially and I'm coming in trying to wholesale it, but they're not okay with the price. I say, okay, well, let's list it, see if we can sell it, then that's completely fine. But if I go into it and I say I'm gonna list it, and then because it's not selling or I change my mind and I say, oh, I want to wholesale it, that's a problem.
It could be, but it really deals with what are the terms of the contract between you and the seller. So if you say in your example, if you're yourself and you're a broker and you're saying, hey, I wanna buy this property, so I have a purchase agreement where I'm the buyer and you're the seller, and then you later decide that I don't really want to buy it. Instead, I'm going to sell the contract to some other buyer and let him buy it. Then you're wholesaling. If instead you say, I want to terminate this purchase agreement, I'm no longer going to buy it. Instead, I'll list it for sale on the open market for you. Then what you'd be doing is having a listing agreement with the seller, and you wouldn't have a wholesale agreement to even as an option, right?
Yeah. So really that actually doesn't really matter unless I'm not upfront about doing possible both options.
Right. And it really comes down to what is your agreement with the seller.
Okay. Yeah, no, I didn't know about the whole five properties and yeah, because I mean I've just been taught that, if you have your license and then you wholesale, it actually is more of a concern, but it sounds like you're saying it's not. And I was told recently that in Chicago, that is their rule that you have to have your license in order to wholesale, period.
You you really do in Michigan. It's just not enforced very often.
Okay. Okay, so that was off topic, but if the seller is holding up the earnest money deposit from being released to the buyer due to a buyer's default for a reason they could not cancel agreement for, how should the seller and buyer best protect him or herself? And I think you mentioned that a little bit earlier, but is there anything
Yeah.
else?
Yeah, one way is to have an attorney fee provision in there. So if you're the seller and you have your whole and there's an earnest money deposit that you're holding, one way to protect yourself is if the buyer tries to back out for an invalid or improper reason, is to say that I'm going to hold this EMD, and then then they can kind of choose whether they wait for the buyer to initiate some legal proceeding to try to recover it, and if so, and they lose, then the buyer would have to pay their attorney fees. um, More likely what would happen is the title company would eventually be annoyed that they're holding on to this money if they're acting as an escrow agent. And so they'd say, hey guys, agents or parties, like we need to resolve this. And so a seller, if there's an attorney fee provision that protects them in the purchase agreement, can contact the buyer and say, look, I'm going to keep this money, and if you won't sign a mutual release, which the contract requires, then I'm going to file a lawsuit against you. And when I win, I'm going to be able to recover my cost and attorney fees in addition to retaining the EMD.
Um, and for those who don't know, a mutual release is a document that officially cancels the agreement for the buyer to purchase a home from the seller. Um, and you kind of went into a little bit, but is it always needed in order to prevent the buyer from suing the seller or vice versa? Or can the expiration or default of any terms and timelines in the agreement be sufficient if there isn't an earnest money deposit?
So I guess to break that up, is a mutual release always required? No, it's not. Often there can be termination of the agreement otherwise, either according to its terms, like you said, a time limit, or like a closing date that comes and goes, or some other, or a limitation on the time in which to bring a legal proceeding or to file a lawsuit. So like a statute of limitations that's contained in the contract. If any of those expire, then anybody suing to enforce the agreement would not have a valid ability to do so. That doesn't mean they wouldn't try. So for that reason, having a mutual release is a cleaner way and probably a better way to avoid potential for somebody filing a lawsuit improperly, because the mutual release releases each side of any potential claims related to the transaction. So it's a best practice to have a mutual release, but it's not a requirement.
Okay. And what if the seller appears to have failed to properly disclose what he or she is aware about the property, and the buyer pursues him or her for this negligence? What would a buyer need in order to make this case, work out for them?
Evidence. And that is I recently had a case where the seller put on her initial disclosures that she did not have any water problems in the basement. And then the buyer bought the property, and the first time it rained, guess what happened? Water in the basement. So they they were fortunate because there was a sticker for a basement waterproofing company that was in the basement. So they called that company, they called the number on the sticker and said, "Hey, I've got this water problem." And then they learned immediately, "Oh, yeah, we know this address. We've been out there, every spring to do some maintenance." And then so the buyer then was able to determine and get the notes and the history from that basement waterproofing company of every time that they went out to the property. And so in that case, the buyer was able to show there was a consistent problem in the basement with water. And they were able to show every single time they went out there, all the advice that the waterproofing company gave to the seller. And eventually they were able to file an arbitration because the purchase agreement required arbitration instead of a lawsuit. They filed an arbitration and we were able to recover like $67,000 for them.
Oh,
Um,
wow.
it became a significant water problem, and it cost a lot of money to fix it the right way. The seller knew that. She should have known that. She should have put it on her initial disclosures. And when she didn't, it cost her a lot of money. But to answer your question directly, what a buyer needs is evidence. And that is sometimes hard. I just had a client call me last week, a potential client call me last week and say, one of the things on the disclosures was that they never had any repairs or maintenance done without a permit. But after he bought the property, he noticed a little bit of leaking in his basement, and he went up and had somebody look at it, had a contractor look at it, and they said they didn't put the proper flashing on, or they didn't, shingle this area properly. So then the buyer went and looked to see what permits had been pulled, and they realized there hadn't been a permit pulled to repair or replace a roof in 30 years, even though the roof was obviously not that old. So now he's stuck with an issue. He probably has enough to file a lawsuit, but it's going to be difficult because he's going to have a hard time proving when that work was done because it's not permitted. So unless he has witnesses, it's going to be difficult. So in order to have a good chance of prevailing in a seller's disclosure type dispute, the buyer really needs to have good evidence. And that could be neighbors, neighbors saying, I saw a roof job being performed, 10 years ago, 5 years, last year, whatever. Or I had a case, another water intrusion in the basement case where, the seller said that there was no problem with water intrusion. And then the buyer bought it. First time it rained, basement flooded. Got involved in litigation and learned from a neighbor that, yeah, Betty, the seller, called me over and I went down in the basement. And she said, "What do I do? There's all this water pouring in." And that evidence from the neighbor showing that the seller knew that there was a water problem is what ultimately let the buyer win that dispute. So sellers' disclosures cases are difficult, and a buyer really needs some good evidence in order to win, unless the issue is so obvious that a seller could not have not known about it. Like there's some obvious issue.
Yeah, yeah, that's always the thing, the water in the basement. I get people who, well, it wasn't much, and there's always something else. You got to put it on there.
Yeah, it's not going to hurt you. Put it on there, let their inspector take a look, and then, it is what it is. Or if there's a problem that needs to be fixed, then, that's just the cost of doing business. You got to fix the problem if you want a higher dollar, or you're going to sell it at a discount. But
Yeah,
trying to hide it is the worst thing you can do because even if the buyer doesn't have a good lawsuit and they're going to lose, it can cost a lot to defend that type of lawsuit, even if you ultimately win. Again, going back to what I said earlier, an attorney fee provision in the purchase agreement can protect either side. So that's always a good thing to have.
Yeah, and even on like a smaller scale, I had a guy last year that he knew there was some water that would come in every now and then, and I said, "Well, you gotta disclose it." He almost didn't want to, and but the buyer that bought the home, um, when they looked at it, there was water, and when we were having the appraisal, there was water, but it was like different circumstances where he really just needed to clean the gutters the one time.
Mhm.
But then the second time, it was heavy rains both times before you have the inspection and before you have the appraiser. And when the appraiser came out, apparently a branch fell on the roof and then leaked through the attic. And then so when you walk in, there was water and you had to fix that. But we let them know both times. And I always say people that really want the home, even with a lot of issues, they find a reason to still proceed and we close. But again, like you say, I mean, if he didn't disclose in the beginning, they may not have trusted the rest of the house because he said there was no water, but they clearly see there's water more than one time.
Yeah, and going back to one of your earlier questions, when should somebody hire a real estate attorney? During that process, that would be a good time to hire a real estate attorney if they wanted to get into some negotiations as to how to resolve those issues. Especially, oftentimes real estate agents don't feel comfortable getting into that type of a legal negotiating process where it becomes more than just the purchase price for the sale. If things get a little complicated, and understandably so, some agents don't feel comfortable negotiating that on their own. Some do, but that's often a good time where a real estate attorney, even just providing advice in the background, could help.
Yeah, no, that's definitely a good point because if they were very concerned, which I don't know, um, then you're like, should I buy the house or not? Yeah.
Yeah,
Because I already see there's issues.
right.
But they wanted it, they got it, and I mean, there you go. Um, but yeah, so some sellers think it is safe to have their cats and dogs in the home during showings, and I think more of the stories I have are with cats, but can it reasonably be the agent's or buyer's responsibility to make sure the pet doesn't escape the home during the showing?
It could certainly be argued that, yeah, that, my real estate agent came in and my cat ran away, and then you got an issue between the seller and the real estate agent, right? So certainly one way to avoid that is to just take your pets out of the home if you're going to be, showing your home. It's a lot easier on everybody involved, and you don't limit your buyer pool because what if the buyer's allergic to cats, or and they come in there and it's or afraid of dogs, or something of that nature. Like it's probably a best practice not to have your pets alone in the house when you're showing the house.
Yeah, that's what I was gonna say. What if the buyer is allergic to pet and it wasn't disclosed? Because so sometimes when there's a dog, they'll say, okay, there's a dog, he's in this room, blah blah blah, and then sometimes they'll say there's cats and let the cat out. But several times I've gone to show a house and there's no disclosure there was a cat gonna be there. And they're real quiet too. So you just go in the room and oh, there's a cat, and there's another cat. And I had one. It's almost inevitable that the cats were not gonna get out because we went through the back door and
Mhm.
just opened the door and the cat just comes out. And they must have had about 15. And
15 cats?
because because one comes out and we're just trying to spend this time to carefully put the cat back in. And once we do that, just more cats start coming and we just couldn't even show the house. But there was no disclosure there'd be cats there. And I just for some reason people feel like, oh, it's a cat, no problem. We just won't say anything. So if you didn't know that if you're allergic, if you didn't know that there was gonna be a cat there and now you're allergic and you come through the house, because sometimes you don't know a cat's there till you've been there 15 minutes because it's upstairs somewhere
Right.
pops out, how would that be handled? Because you are still going to someone's personal home, but then it is for sale.
Yeah, I mean, I think that a prudent seller would disclose that at a minimum. Just tell their agent that hey, there's animals in the house. I just so you're aware, or don't let it out, whatever the case may be. So I think that a good agent would probably make sure that they're asking that question before they're listing the house too, right? Like, are there any cats? Is there anything else we should know about before we're having potential buyers walk through? and show the house. So I think that's something that every agent should probably try to cover with their clients that they're listing. But it's certainly something that everybody that's selling a house should be aware of too, and should go out of their way to make sure their agent does understand and know that, so that they can tell, the buyer's agents.
Yeah. But I mean, I think sometimes they do know. I mean, it's not say for sure, but I'm assuming that when you've gone to list a house, they were there then. But if for some reason it wasn't disclosed and now this person has a really bad allergy and they have to go to the hospital, like that is cause for a lawsuit if they decide to do that.
I don't know if it would be a winning lawsuit, because it could be argued that that's an assumed risk, that if you're going into somebody else's home to buy the home, that you don't know if they've ever had animals. And if somebody's that allergic, then whether the cat's in there or not is not going to really matter, because, the cat's going to live there, and whatever other, it's going to be signs of a cat. And so if they're that allergic, they're going to be allergic regardless of whether the presence of the animal is there. So I would say that it would be a difficult lawsuit to win on, because I would say that that's an assumed risk, that if you're walking into somebody else's home, they could have an animal there, or whether it's not there now, they could own an animal that lives in the house.
Makes sense. And what if, same thing if they, bite or attack the person that comes in?
Yeah, that's something that, that it would be really fact specific to that situation to determine what type of claim there could be against the seller, or against an agent. So it would really depend on the specific facts in each situation. So it's hard to say whether there's a bright line rule, that yes, this is something that would cause liability or not. So really, the best practice would be to make sure all of this information is disclosed. If you have a dog, you probably shouldn't have the dog there when you're not there and somebody's coming to look at your house. That's not a good idea to avoid that problem. Because if there is a dog bite, it's probably going to result in an insurance claim on your homeowner's insurance. And, it could, if it's happened before, it could result in the dog being put down. So that's something that, sellers should be aware of and concerned about. And again, the best practice, don't have your animals in the home when you're showing them.
Yeah, and this is a different subject, but some of it kind of goes into fair housing, right? So people have ring cameras so they see who's coming in and the animal and all that. So I've had a scenario where someone's bringing their dog with them to the house to see it, whether it was an emotional support animal or seeing, but I'm seeing like, well, for the most part, if it's a dog they help you with seeing, you probably aren't looking to see the house, right? But outside of just saying, okay, can't have any pets, don't bring your pets to the showings, but someone brings an animal that is there for some kind of support, but it is someone's personal home, and maybe to that point, maybe they're allergic to cats and dogs. Is that a is that a whole different thing? Because depending on who answers the question, if it's for fair housing and it's an emotional support animal or a service animal, some will say that it is not okay. You have a right to not let them in, or some say it's not okay because your house is on the market.
I think that, that's something that you should, if you're really concerned about, you should put it in the purchase agreement, or you should put it right there in your listing agreement with your agent, that, I don't want anybody coming in with animals to my home. There's less of a concern if it's a privately owned home, and I believe that you can set those rules. I guess there could be some arguments for, ADA requirements in certain public housing situations or government housing situations that might have a different answer. But um, overall, I would say it's not a good idea to bring pets to a home for showing, or to leave a pets there if you're showing your home. Emotional support animals, I guess, would be a rare exception to a situation where you might be more inclined to allow an animal into your home, or be required to, depending on who the owner is. Um, so there's no clear answer there, I guess. It really depends on the facts of the situation.
Okay. Um, And I think I know the answer to this, but it's another question I didn't have on here for you. Because of the cameras, right? So, in my listings, whether I see the camera or not, I'll just say, there may be cameras or home may be under surveillance. If
Yeah.
that's not there, is that a problem? Because it still is someone's personal home, but it's a private showing, but you're in someone else's house. Is it a problem if it's not disclosed that there are cameras in the house?
I think that, you've got to, I'm not aware of any law that prohibits having cameras in your own home, even if you're showing it to potential buyers. So I would recommend if I'm bringing somebody to a home, assume that there's cameras, especially in today's day and age. Assume that there's a nanny cam or that there's a ring cam, or that there's a recording that you're not seeing. So don't do anything that you wouldn't want recorded. And that shouldn't be an issue, except sure there may be more politeness, right? So if a potential buyer is walking through a home, they're like, "Ooh, man, the color on this wall is terrible." And that might offend the seller, but just understand that the seller could hear these things.
Yeah, I mean that's been the whole conversation topic is okay, well, now we can match this person with them being the buyer, that was their agent. Now the seller may have something if they're paying attention like that to say, "Oh, well, I don't want to accept their offer because of their race or because of this," and they didn't like that, now they can be discriminatory, but I feel like most people they're not even paying attention to even try to line that up and they want to just sell the house. So,
Sure, I mean that's a potential, but maybe remote problem, but it
yeah.
could be a problem.
Okay. Well, that's all questions I have. Is there anything else that you want to add?
No, not really. Thank you very much for having me. I think it's great that you're having these types of discussions, and you're really setting yourself apart from other brokers and agents, for even recognizing that there's a hole in this type of knowledge for a lot of people that are buying and selling a home. So, I think you're doing a great job, and keep that up. And thank you very much for having me.
Yeah, no, thank you so much for acknowledging that. Yeah, I always try to do a consultation with all my buyers before I show them anything, and there's only limited time for the sellers, but I always feel like the more people know, the easier the transactions can be. They're not as overwhelmed because it's already difficult enough going through the process of buying and selling, but then you don't know anything. You know things as you go along. It's just you can't make always the best decisions and you can be more stressed out. And yeah,
Absolutely.
all
Absolutely.
these shows don't help us either. They make it look like everything's super simple and easy, and it's
That's
not.
true. That's true. And it's sometimes hard for agents and attorneys to kind of remember that and keep that in mind. I mean, you and I do this all the time, right? We're involved in real estate transactions daily. But for most people buying or selling a home, they don't do it that much. Some people will own a home for 30, 40 years and only buy or sell a home twice in their lifetime. So, we got to remember that there's a lot of overwhelming things, like you said, to these people that are buying and selling homes. And to the extent we can provide the education and make the process easier, I think that's good for everybody involved, and that's one of our main jobs.
Yeah, no, I know definitely. Things always change, and I've
Yeah,
had people that buy and sell homes all the time, but they still have tons of questions,
yeah,
and we
yeah,
always have to learn. So, but
absolutely.
yeah. So, how can if someone is looking for a real estate attorney for any part of their transaction, whether it's very difficult with probate, short sales, or just everyday stuff, how can they reach out to you and your team?
Sure. The best way would be either going to our website, which is headmurphylaw.com, or giving our office a call at 248-939-5405. And our staff will schedule an appointment with an attorney for a free consultation. And all of our attorneys here would be happy to talk to anybody that has any real estate questions and see if there's anything that we can do to help them.
All right. Well, thank you so much for your time, and this was very helpful. And I hope you enjoy the rest of your day.
Thank you. You as well.
Thank you.